Good morning, everybody, and welcome to today's webinar. My name is Miles Hanson. I'm the president and CEO of World Trade Center Utah, and we're excited for today's webinar, Spain after COVID-19, New Regulations Explained from a Practical Perspective. Right off the top, I'd like to thank our partners on this morning's webinar, Harris Bricken and Monereo, Meyer, Abogados. Harris Bricken, they've been members of World Trade Center Utah for just about a year now, and they're phenomenal partners. They've got deep expertise here in Utah, in China. We've done several webinars with Harris Bricken on China. They also do cannabis and other issues. And of course, they have strong relationships across Europe, including in Spain. So we're grateful for Harris Bricken for all that they've done to help provide training and expertise for our Utah companies. And we're very grateful for our friends at Monereo, Meyer, Abogados for joining us. They have finished up their workday on a Tuesday evening there in Spain. And so we're grateful that they take an extra hour or so to be with us today here to help all of us get a better perspective on the changing landscape in Europe and in Spain, and what that means for our Utah companies that are doing business there, as well as talking about how we can identify opportunities in this changing landscape so we can help our companies continue to grow and expand. For anybody joining us for a World Trade Center Utah webinar for the first time, I just like to emphasize, please reach out to us. We do these webinars to help provide expertise, to help you have the business insights that you need to go and compete and win globally. And we also are here to help you follow up. I'm a strong believer that we measure the success of our webinars, not just by the quality of the content, but by the positive action that takes place after the webinar that leads to new opportunities for our Utah companies. And so we want to help you take action. We want to be cheerleaders and supporters in your efforts. We can provide grants to help offset costs. We can help you do free, market research consultations, help make introductions with our panelists today, as well as other partners that we have in Spain and elsewhere in Europe. And so we strongly encourage you to reach on out. Hannah will make sure that she puts her email address in the chat. And we want to hear from you and find ways that we can plug in and help support the good work that you are doing. This morning, I'm very honored to have a close partner and friend join with us here in Utah. Baldomero Lago is the honorary consul of Spain. He is also one of the most influential people when it comes to Utah's international engagement. He runs a global program at UVU. Baldomero was responsible for bringing the United Nations here to Utah a little more than a year ago. He's a tremendous asset. And again, Baldomero, it's great to see you. We're grateful for all that you do. Now they give you a chance to provide just a couple brief introductory remarks based off of your expertise with your native Spain. So Baldomero, I'll go ahead and pass the baton to you, and then we'll go ahead and proceed with the program.
Thank you, Miles, for that wonderful introduction. It is an honor to be with you and with all the individuals that are part of this webinar this morning. I will not take too much time because I'm just simply submitting my greetings to everyone and to make sure that they understand, anyone understands here in the state of Utah and abroad, that we do have a government representation in the state through the consulate, that we are very well connected to the commercial office in Los Angeles. And if there's any partners that would like to develop any ties or any building into relationships with Spanish companies and vice versa, if there are Spanish companies that would like to tie or bring connections through the World Trade Center Utah or other partners, please let us know that I'm at your service. This is a great opportunity. We have a small community of Spanish citizens residing in the state of Utah. Approximately 1,600 or 1,600 Spanish citizens live in the state. But we want to make sure that we are strong when it comes to global enterprise, global engagement. So again, I've been serving in this capacity for 21 years. I do have a few connections both here as well as in Los Angeles, that's our headquarters, as well as in Washington, D.C., and of course through the commercial office in Spain. So we welcome my colleagues in Spain. Bienvenidos. Buenos días desde Utah. Buenas tardes en España. And so I hope this is a very fruitful webinar today. And again, I'm at your service. Thank you, Miles, for this brief introduction.
Great. Thank you, Baldomero. I appreciate that. Now, as we jump into the program, I'd like to remind everybody to please treat this as a discussion. You've got great expertise on the call today. And so we want to see questions coming in through either through the chat function or the Q&A function. We'll reserve some time at the end to go through and answer your questions and make sure that you're able to get the specific information that you're looking for from the experts that we've got on our call today. Without further ado, I'll go ahead and introduce our first speaker. Ms. Nadia Vaetz is a partner at Monereo Meyer Abogados. Nadia focuses on assisting American and European companies in their foreign direct investments into Spain and Germany, and on assisting European companies with their foreign direct investment into the United States. With 3 law degrees and licenses to practice law in Germany, Spain, and the United States, Nadia is uniquely equipped to help our clients navigate cross-border transactions and legal disputes. She applies her broad legal knowledge and her experience from working in different work cultures to help our clients achieve their international business goals. So Nadia, thank you. Good evening to you. We're grateful that you take some time to be with us, and I'll go ahead and hand it over to you.
I need to unmute myself. Thank you, Miles and Monereo, for the nice introduction. I'm gonna share my screen with you for our first presentation today. So thanks for the introduction, and good morning and welcome to all of you. Thanks for joining us here today, and mostly thanks to the WTC Utah for sponsoring and organizing this wonderful and timely event. Thanks also to our colleagues from Bricken for helping organize and for getting the connection. And as Miles explained, I'm licensed in 3 countries. I'm also licensed in Washington State, and I actually practiced almost 10 years with Dan Harris from Bricken, and that's where the connection comes from. So this topic today, we picked it because we wanted to give you an update about the current situation in Spain, which has been hit hard by COVID-19. There are several new regulations in place which change the business landscape for foreign investors, and we thought to give you an overview of new regulations, new pitfalls, and new opportunities as well. There's a lot of topics to cover, and we have prepared a lot of material, so it might seem that we are rushing through it, but we really want to give you just some general idea, and if there is questions at the end, of course, there's a Q&A session, and also we will be happy to answer those if you send them to us via email. So let me jump right into it, if it works. Hold on. Okay, so this is going to be our presentation today. First, the first part is my brief overview of new and old legal issues, which is basically just to give you an idea of what we typically encounter when clients are coming to us, the issues they see in Spain that they might not be used to from the US. And then Andres Monereo will talk briefly about distribution channels in Spain in times of COVID-19, and then it goes back to me and Consuelo to talk about new restrictions in FDI and also some IP law and GDPR. But first of all, I would give a quick introduction for our law firm, Monereo Meyer Abogados. We've been around for 30 years, so it's a catchy title, but yet we just celebrated our anniversary last year. We're about 30 lawyers and 3 offices here in Spain, in Madrid, Barcelona, and Palma. And most of our lawyers are fluent in several languages and licensed in at least 2 countries. And it all started out to be mainly focused on German-speaking clients, but then I joined the firm, and of course I brought my expertise, and since then we've been working more and more with US clients and clients from out of the European Union. We are a full-service law firm focused mainly on corporate, litigation, real estate, and within corporate there's of course M&A, tax, employment, commercial agency, IP, technology, and so on. And with that, I would like to start my part of this presentation, which is basically to give you, again, a quick ideas, topics on hand for what you need to look out at once you go to Spain, and what you will find here in this a bit different landscape, or legal landscape and business landscape. But first, I would like to give you some numbers. And these, of course, are the numbers for Spain that we used to give last year. It's all pre-COVID. The United States is a very important trade partner for Spain and vice versa, and I don't believe that has changed much. It was first in investments in Spain with 16.4% of total investments, and second investments from Spain with 15.5%. And of course, I could not find any numbers to directly compare with those from last year. But speaking about investment, must be said that the spread of COVID-19 has touched every facet of the Spanish society, and the scale of the humanitarian crisis has been matched by widespread economic disruption. And I found this most recent McKinsey report that predicts or assumes that Spain's economy will recover by the end of 2023. And they divided Spanish industry in three sectors, three big blocks. So the first one is the one that has been hit the hardest, which dropped more than 20% in revenue, of course, accommodation, food services, entertainment, car, real estate, and those will take longer to recover. Then there's the middle part, which had a drop of between 10 and 20%. And then there's the sectors that dropped 10 or less in their gross value in their revenue, which we're focusing on this last sector because we think that that sector that suffered the lower short-term demand hit may focus on what their business will look like in the future. So they might rethink if they pursue traditional business models or explore new ones, and we're expecting it might mean a wave of M&A for the near future. Of course, some changes are here to stay. We have seen a significant impact of the contract-free economy and accelerated digitalization, which is good, and more pressure on contract-free, on just-in-time and zero stock approaches. And yet, despite all this recent development, we remain optimistic. We do think that Spain remains at the forefront of foreign investment, and it is a very, very good climate for foreign investment because there are several factors, and I've listed them here. The legislators' intentions are generally very foreseeable. We have tax incentives in place now for foreign security. There's a foreign securities holding companies concept. Then there's tax incentives for Spanish companies, even with the beneficial owner from outside the EU that invest in South America. There's tax treaties with 94 countries to avoid double taxation. We have very competitive labor costs and labor laws that are attractive for entrepreneurs. We have, Spain is part of the EU framework, which means competitiveness and service and product markets liberalization. And we have after several years of re-elections, we have now we have a government, so the political situation has stabilized. And so we are very optimistic when it comes to foreign direct investment. And here are the issues, the topics I wanted to give you, which are generally speaking different from what you might be used in the US. So there's the commercial agency law, which can be very onerous and strict in Spain and Spanish law. You should be aware of that. Then there's contract law, which can be different. Forming a company will be very different from what you are used in the US. There's very strict anti-money laundering laws here in Spain. We have employment laws that are very different from what you're used in US law. And the IP law.
Yes. Sorry to interrupt real quick. I just want to make sure, do you have different slides that you're referring to? On the screen, we continue to see the main cover slide.
Okay. Oh, you can still, it doesn't move?
Nope, it hasn't moved yet. And I apologize, you were doing such a good job explaining everything. I didn't pick up that you could be running through different slides, but then a few of our participants flagged it for us in the chat. So thank you to Giovanni and a couple others that asked that question.
Thank you. Let me stop sharing and then I start again. And hopefully that will fix the problem. Share. Do you see now different slides?
Now we see it. Perfect.
Okay.
And just a note for everybody, we will send I assume that we can get a copy of these. We'll send these out to everybody after the fact. And so then you can go back and review the slides up to this point.
Okay. Yes, we'll be sending out those slides. So there was the information I've been talking about, the numbers, and then the differences in law, of course. I was just going into commercial agency laws, and which I will not explain much in detail since Andres will cover that topic later in this today's webinar. But you need to be aware of once you go into Spain and want to sign your distribution agreement, you need to know that agency law is very different, can be fairly strict and onerous, and you want to have a good contract in place to avoid any indemnity claims later. Anything else is not important to know, but you need to make sure you sign the right contract even with your distributor. And then speaking about contract, that's typically a slide I would consider more important in US law, not so in Europe, but yet you still need a good contract for clarity, prevention of conflicts, and enforcement. And I say that because that's what we see in our daily work here. Spanish clients just start doing business and they never trouble with signing a contract, and then we find ourselves representing them in court. So one thing that's different from the US is that digital signatures are not as widely recognized in court yet. So you want to sign your contract in a very old-fashioned manner, and you want that one with one valid language, choice of law, and venue clause, of course. Also, so once you consider hiring employees in Spain, or once you consider renting space or renting office or space or warehouse, then you might be considered a permanent establishment. And at that point, it might be better for you to form a company in Spain. And that's when you really find differences here, because you cannot form a company overnight and online, as we used to do that all the time in the US, of course. It still can be done, but you need to consider a different cost and time factor. You need minimum capital, you need bank account. And the most popular two company forms you have are the limited liability company and the joint stock company. Not much in minimum capital, it's 3K for the limited and 60K for the joint stock company. But take into account, as I said, the bureaucracy and formalism. And if I had colleagues here from our alliance firm, Bricken, they would confirm that they are astonished. They're surprised, to say the least, when they come here and want to form a company. It can be done, but you need to count more time, of course. And I used to say, we form a company and get the tax ID for that is needed to start your activity in 4 weeks, and you have to double that if you want to hire employees. But then we have the new FDI screening regulation in place now, so you might need more time even, because you might need a prior authorization for your investment. And also you need to keep in account, or take into account, the very strict anti-money laundering rules. And I put all these laws in here, just a little boring, but you need to know that this is based on EU law. So this is the whole for the same EU. You will not only find that here in Spain. You need to be prepared for full disclosure. That means the ultimate beneficial owner needs to be revealed to all advisors and banks involved. And I say that because that's what US clients are usually not liking when they come here, but then that's what it is. And you need to be prepared for that, and prepare your investor to disclose for that disclosure. Employment matters are very different. You probably know that we don't have the at-will contract here as you're used to in the US. We have the worker statute and applicable collective bargaining agreements that define your employment conditions. And for FDI matters, once you want to purchase a company, you need to be aware of that. That can be considered a transfer of a business as a going concern, which means it can trigger joint liabilities for both the purchaser and also the seller of that company. And then there's different new regulations in place now with COVID-19. We have the workplace security regulations, remote working laws, and also ERTES, which is regulation for temporary redundancy to help companies get through the pandemic crisis. And that's my last slide for this first introduction. Again, IP laws are very different. GDPR is something you should know about. You should be prepared for that. And there's several state of alarm legislation we have seen recently. And with that, I want to finish my first introduction and not want to bore you much. If there's questions again at the end, I would be happy to answer those. And I would like to give over to Andres now, who will be talking about distribution channels in times of COVID-19.
Hello to everybody. I hope you can see my presentation right now. It is okay?
Looks
Okay.
good.
Yep. Looks good.
I'm Andres Monereo. I'm founding partner of Monereo Meyer, Abogados. I'm a corporate and commercial lawyers. Thank you to the audience. Thank you to Nadia for this introduction. Oh, I think I have a problem with my slides. Okay, now I'm going to talk about how to sell products in Spain through the distribution channels. Well, maybe at the beginning you may decide not to sell your products abroad, specifically now in Spain, with your own subsidiary, with your own structure, not to invest in fixed costs, not to hire workers. A couple of tips about the cost of the workers for the companies. This is the social security cost is 33% of the salary, and there is a severance of 33 days of salary per year when you dismiss a worker. So maybe you decide to use third-party structures, and here you'll find two different figures: the agent and the distribution. The agent is an intermediary. He put in contact the producer and the clients and receive a remuneration as a payment. Meanwhile, the distributor acquires the products from the products and apply at the corresponding profit margin to this. Usually the distributor is a more complex entrepreneur. He has his own structure, normally warehouses, workers, etc. Because of this, it has been always considered the stronger than the agent. And because of this, there is a specific law for the agents, which come from the European Union, and it is clearly a very protective law. The good thing of my speech is that you can apply all the things I'm gonna say to most of the countries of the European Union, because this law is very similar to the Italian, English, and French, etc. laws, because all of them derive from the European directive. Well, the first thing, it is about the form of the contract. There is not need for a writing form. There is freedom of form. In Spain, you can contract agents or distributor only with an interchange of emails, but we highly recommend to draft contracts. For example, with the agents, the very specific and interesting clauses as non-compete provisions, post-contractual non-compete provision only can be agreed if they are written down. The choice of law is also free for the parties. I mean, you could apply or decide that the contract is submitted to the the American law, but you have to take into account that because the agency law is very protective, there are certain regulations which are mandatory. So you cannot establish regulation different or contrary to those mandatory regulations. Now, the remuneration point is, well, as I said, the distributor add the margin to the products that buy to the producer, and the agent receive a commission. This commission could be a fixed commission, for example, a monthly fee, or what is more common, a variable payment based on the volume of sales, for example, or other facts. now I would like to talk a little bit about the what I call the COVID clauses. We have seen during the first wave of the pandemic that there were strong effects from the pandemic to the contracts, and very few contracts have regulation about the force majeure, or about, of course, not about the pandemic, because I think nobody thought that it was possible. But I will recommend not to leave this question aside, because the discussion of the effects of the pandemic on the contracts to the courts, it is not a good idea. It is better to regulate, for example, if the pandemic it is or not a force majeure event. I mean, if, for example, if there are lockdowns of the commercial activity, as it happened in our first wave, where when the retail activity was forbidden to the public. I mean, all the commercial units were closed. And for example, what happened with the contract, the lease contract, the rent has to be paid or not. This is really a mess, and we don't have enough case law applicable to this situation. So please think about this when you initiate your business in Spain and write your contracts. Well, now I'm talking about a very specific and peculiar topic on the agency and distribution agreement, which is an indemnity that the agent or the distributor are entitled to receive from the producer when new customers were acquired, or sales with existing customers were significantly increased. And apart from this, there are substantial benefits for the business owner, for the producer, after the end of the contract as a result of the agent intermediation. This is a sort of goodwill indemnity, and there is no a legal calculation formula. There is a maximum amount, which would be an annual remuneration calculated on the average remuneration of the last 5 contract years. You can imagine that it could be a high amount if the agent or the distributor have sold and receive a high compensation for this. For the agent, the calculation is on the remuneration, on the commission, but in case of the distributor, the calculation of the formula is based on the net profit, on the margin. And of course, here there can be a lot of litigation in order to establish what is the margin of the distributor. There is also another peculiar compensation for the agent, not for the distributor, and it is related with the investments made following the instructions of the producer if such investment have not been amortized. In that case, the agent is entitled to receive the amount of the investment not amortized. Other legal relationship, and is the risk of labor classification in our case of the agent, and the risk is because the condition of the agent as an entrepreneur, as a self-employee, changes to an employment relationship. And this is because, well, at the beginning, the agent or the distributor is really a freelance, is an independent party, but at the end, there are some circumstances that transform the relationship into a laborship. For example, in many cases there are or there is a clear presence of the agent at the employer's premises, at the producer's premises. There is a submission of a working time. There are payments from the producer of agents' expenses like internet, like tools, for example, computers, whatever. And all these circumstances leads to a subordination of the agent as a part of the disciplinary circle of the business owner. The consequences of this labor classification is very severe. From a labor perspective, the agent will be considered as a permanent employee, and for example, if you terminate the relationship, he can ask you for the severance compensation I mentioned at the beginning. But also there are other very, very severe consequences regarding social security perspective. And the administration, the social security administration, can ask for the producer the unpaid contributions since the agents was hired, and these are 4 years of a statute of limitations, and it could be a very, very high amount. Also fines. Also, in case there is a liability, in case there is a labor accident, an accident of the agent, because the agent is not covered as a worker with an insurance, a specific insurance, and the producer may be considered liable for the consequence of these accidents. From the tax perspective, also, if there is this classification of the agent into as a worker, the tax administration may ask for the unpaid tax withholding, and also here it could be claimed the last 4 years of unpaid tax withholding. So at the end, this could be a very important consequence. So what is important is try not to attract the agent to your circle, try not to control everything, try not to make the decisions of the business, of the agent business, for example, the customers' selections, etc., and leave it for the agent. And this is well, a very short and specific trip to the distribution channel. Thank you very much. And now I think Nadia leads again with the presentation. Right now, okay.
All right. So I'm sorry, I was kicked out of the meeting for a second. Some technical problems here. Thank you, Andres. I'm gonna try sharing my screen again.
Sorry for that, Nadia is having problems with the connection, so I will continue with the presentation. My name is Consuelo Alvarez. I am in the Office of Barcelona of Monereo, Meyer, Abogados. And I'm going to talk about intellectual property, how to protect intellectual property in Spain, and the situation of the registrations in the Spanish Patent and Trademark Office during the pandemic. And I'm also going to talk about GDPR, data breaches, and the most frequent questions asked during the pandemic regarding personal data protection in Spain. So, for the protection of the industrial property, it's the one first to register and not the first to use it. So the Spanish Patent and Trademark Office is the public Spanish institution responsible for the registration and granting of the different types of industrial property for the territory of Spain. All the rights awarded by the Spanish Patent and Trademark Office have effects in the whole national territory. And the titles that can be registered include trademark and trade names, industrial inventions such as patents and utility models, industrial designs, and topographies of semiconductor products. Of course, the protection of some of these rights can also be achieved by the registration within a supranational organization, such the European Union Intellectual Property Office and the World Intellectual Property Office. But we're going to focus on the registration for Spanish territory of Spain. The main legislation in these topics are the law on inventions and patents, law on trademarks, law on the legal protection of industrial designs, and the law on legal protection of the topographies of semiconductor products. So during the pandemic, the Trademark Office interrupted all of the deadlines for all of the procedures on the office, and they resumed the procedures the 1st of June. Well, this interruption of the administrative deadlines, of course, affected industrial property procedures within the Spanish Patent and Trademark Office. However, this didn't mean that the interested party could not carry on with their procedures within the office. It only meant that the deadlines were interrupted for this period of time. During the declaration of the state of alarm, the office continued to develop actions to guarantee improvement of the electronic services and adopted measures to avoid damage to users of both the Madrid system and the Hague system. And this speeded up the processing of procedures during the closing period of the office. And these measures have improved, like overall, like the functioning of the electronic services. So this has been something positive that came out from this strange period of time. And also during the pandemic, we have noticed that there has been an increase in resolution of disputes on technology and intellectual property during the COVID-19 pandemic with the mediation of the WIPO Arbitration and Mediation Center. And also there has been a very high demand for other alternative dispute resolutions. Number of for the last 2 years for patents, trademarks, industrial designs, trade names, and utility models in the Spanish Patent and Trademark Office. As you can see, at the beginning of the year, it was quite, there were not so many applications as in other years, but it seems that during these last months, the companies have been investing in their intangible assets, and the number of applications are in some cases even better than in the previous years. So this shows something positive to come. With regards to the one question that we always get asked is how to avoid data breaches. It's very important to avoid data breaches to understand the responsibilities that a company has, that the data controller has with regards to the processing of personal data. For this, it is very important to make a risk assessment and an impact assessment before the processing of the data. This, we call it privacy by design and by default. So thinking about personal data protection before making any activity or processing of the personal data. Of course, in order to avoid data breaches, it's important to implement and update data protection policies and procedures, which include security measures in an organizational scope and also technical scope. It's also important to train employees on personal data protection. The constant surveillance is important, and when transferring data or working with data processors, to do it on with a data processing agreement, and only transfer the data to data processors that provide enough warranties. Of course, this is also an obligation according to the GDPR to have a data processing record. If any personal data breach is not according to the General Data Protection Regulation, this will be considered a very serious infringement, which could involve an administrative fine of up to 10 million euros, or in the case of a corporation, up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher. Data subjects may lodge complaints with a supervisory authority, exercise their right to an effective judicial remedy against a supervisory authority or against a controller or processor, and exercise their right to compensation and liability. If there is a data breach, is to notify the Spanish Data Protection Agency within 72 hours from time of awareness. This will only be required if rights and freedoms of data subjects have been compromised. And the notification must include a description of the breach, a description of the possible consequences of the breach, and a description of the answering measures that the data controller and data processor has adopted because of the breach. Another obligation of data controllers and data processors, if there's a data breach, is to have a record of the breach. And in some cases, when there is a high risk to the personal data of the data subject, the data subject must be notified of this data breach. Been asked during the pandemic with regards to personal data and COVID-19. Some of these questions are: may employers process the information on whether employees are infected with the virus? May they transfer such information for the rest of the staff? Can employees and visitors to the company be asked about countries they have previously visited or if they have symptoms related to the virus? Is it permissible to process employees' health data related to the virus? In case of preventive quarantine or symptoms, is the employee obliged to inform his or her employer of the circumstance? And is it possible to monitor the temperature of employees in order to detect the virus? This kind of information, normally it would have been very difficult to obtain from a data controller, from the data subjects for a data controller or a data processor. However, in this case, the answer to all of these questions is yes. The reason for this is that there is a legal basis of public interest. However, the processing of this personal data will always have to obey the principles of proportionality, minimization, and limitation to purpose. So this has been something very different that has been applied only for this pandemic.
Hello. Okay, sorry about that. I was kicked out again.
It looks like Nadia is frozen again. So in the meantime, Andres, I'm gonna ask you a question just until we can get Nadia back on for her presentation. So Michael has recently been experiencing extreme difficulty getting China-made goods into Spain. These goods to wholesale dealers are often stopped by Spanish customs for months. Have laws or document requirements changed for made in China products, or do you have any suggestions or tips as to why made in China goods shipping from the US to Spain are often stopped?
Sorry, it was a question for me. Sorry, I did.
No, you're okay. So a lot of made in China goods are being stopped for months in Spain. And they were just wondering if you have any suggestions or tips as to why these are being stopped and how to kind of go around that system. Is it just the made in China? Or...
Sorry, I can't hear you properly. There is an echo and I can hear you.
While Nadia gets all set up, so there's a question about made in China goods. They're asking so a lot of wholesaler dealers their goods being shipped from the US to China or China to the US are being stopped in Spain for months on end. And they're wondering if there's any suggestions or tips as to why these goods shipping from the US to Spain are stopped and what they should do about it.
Well, I'm not sure the exact cause of this problem, but if maybe there has been any kind of deposit of the goods in Spain, so in that case, some procedures in order to control those deposits has to be fulfilled. I'm not sure because I don't know exactly how was the traveling of those goods through Spanish warehouses, for example, or not. But maybe this is the question. I don't think there is a legal reason, a specific legal reason because we are not in this war against China like you are in the States, so we don't have this kind of let's say political or pressure or measures. There is no reason to think about a specific problem for those delays. No.
Great, thank you for that, Nadia. It looks like we have you back, so I'll hand it back over to you.
Okay, let me briefly show you what we had prepared for you about the FDI new screening regulations, because it's very interesting, and I think there's something you want to know if you want to go into Spain. Okay, let me slide back. This is Consuelo's presentation. There have been some very interesting changes in EU law and also in Spanish law. You guys from the US, you know about the FDI screening, and we've had pre-COVID-19, we had a very liberal framework here in Spain, and in the whole EU, you pretty much only had to notify about investments being done. So they would sign and close the transaction, then fill out the form and notify for statistical purposes. But then there's a new FDI screening regulation in place since last year, and that will come into force now in October. And it gives the framework for EU screening mechanism and list of factors potentially affecting security. And it also introduces cooperation mechanism. And what that means for you from a practical perspective is that you might need for you FDI in Spain, you might need a prior authorization. Investments under 1 million euros are exempt, and there's an accelerated procedure in place for up to 5 million. But anything else that goes into certain sectors might need prior authorization before you get through with your transaction. It's very interesting, and I'm not going to bore you with all these details of the new Spanish laws, but when it goes, the definition is based on the residency of the director and of the 10% taking control in the Spanish company. When it goes into certain sectors, you might need prior authorization to get through that transaction. And the the list of these sectors that are considered critical sectors is very, very long and broad. And what bothers us most is the personal data, that's the sectors with access to sensitive information, especially personal data. And ever since GDPR, all entrepreneurs know that almost any sector these days will touch some kind of personal data. So we all hope that the authorities here in Spain will not be interpreting that law in a very restrictive manner, because that will slow down all FDI. And it's not to scare anybody, it's just that you need to be aware of that, because you might need more time to get the transactions through. And then the other part I wanted to briefly mention after Cancelo's interesting speech was the very strict anti-money laundering rules here in Spain, that you need to be prepared for pretty much for disclosure of the ultimate beneficial owner of your company that will be moving funds into Spain. And important is for you to know that this is, again, as most of our laws is based on European laws, and we find that everywhere in Europe. And important also that all relevant parties that will be involved in your transaction will need to apply those standards and procedures for identifying and accepting customers, and do the screening of the customer depending on the activities and of the origin of the funds. And also, it's not only for the transaction itself, but any related procedures that you plan on doing. And you need to open a bank account, you might want to sign a public deed, an notary deed, you acquire real estate. All of these will require the anti-money laundering screening, and you need to disclose the nature of the activity and the origin of the fund and the ultimate beneficial owner. And there are high fines being imposed, so there's nothing you should be leaving out. Thanks for your attention. Sorry about the technical troubles, and with that, I rushed through the presentation, and I don't know if we have time now. I forgot my phone. We have 4 minutes left for questions.
Nadja, thank you so much for that presentation, and we're so sorry for all the technical difficulties we've been experiencing. If anyone is able to stay afterwards, we can go a couple minutes over, but if not, we will follow up via email with some of these questions. So I'll go ahead and get started with some of the questions we've received. Is severance only paid to employees, or does this extend to hired third parties?
No, severance is typically a payment and indemnity for employees, and well, you got this kind of indemnity specifically, but it's a goodwill indemnity for the agent that I mentioned, that also applies to the distributor by analogy, because it is not regulated, but because of the case laws, also distributor has this right. But yeah, severance is only for employees. 33 days of salary per year of duration of the worker contract.
Great. Is it in a distributor or agency contracts, can force majeure still be invoked due to foreseeable events, or is it only the unforeseeable?
Well, in principle, the force majeure, when it's not regulated, consider unavoidable events. So if you don't have a specific regulation, contract regulation, for example, the first pandemic, in my opinion, was an unavoidable event. I'm not sure if the second one will be considered, because everybody knew at the beginning of the first wave that this could happen again. For this reason, I highly recommend to treat this to try to regulate this question in the contracts. It's very difficult, because you have to imagine the future, and always this is you will possibly think in facts that then will not be exactly what you are thinking about, but at least you may give some orientation to how to deal with this situation, no? in the future.
Great. We'd love to hear your input on the restrictions of mobility of people due to the COVID-19 pandemic, since it definitely affects the business from the US investing in Spain and vice versa. We know that some companies are bypassing these restrictions by having their employees apply to temporary visas when they need to travel back and forth between countries. How do you envision the impact in business relationship between countries, especially considering that, unfortunately, the second wave of COVID-19 is now a reality in Spain?
Nadia, would you like to answer this?
Yes, and I know that there's lots of restrictions, and I unfortunately I'm not very familiar with the Spanish side of immigration law, but I know on the US side it's all been suspended for now. There are no visas issued, and I think might be the same from this side. So currently it is right. It's a good question, and there's no good answer to it right now.
Yeah.
People can have mobility, can be moved, employees can be sent over. I don't think so, not in person. It will all be based on home office, on remote work, and we've seen that in the first wave and in the middle of March, when companies wanted to, from outside the EU, wanted to send employees over, they couldn't. There was just no way, and they had to set up those employees remotely.
Great, thank you for that. This question is for Andres. This is kind of about the analogous application of the agency contract law to distributor contracts. You mentioned that it's possible through jurisprudence. Does this mean binding precedents or similar to those existing in the US?
Sorry, what do you mean with the analogous application?
Yeah, the application of the agency contract law, distributor contracts. You mentioned that it's possible through jurisprudence.
Jurisprudence,
Yes. Does that mean binding precedents similar to those existing?
Yeah, these are the court rulings, because you know that our system, our European continental system, is mainly based in regulation, but also there are the possibility of jurisprudence of rulings from the Supreme Court, for example, that can establish as a regulation itself certain issues, and here all the analogous application of the agency law to the distributors are by the way of court resolutions, court rulings. Yeah.
Great, thank you for that. I know we're out of time, so I just have one last question for you guys, and then we'll let you go. Do you think that Spain can be depended on to create laws protecting businesses due to COVID and other globally disrupting events? Or do you think that businesses should add specific clauses for these sorts of situations to protect themselves? Do you want me to repeat that?
Nadia?
Yes.
Yeah, so
sorry.
You're good. Can Spain be depended on to create laws protecting businesses due to these disrupting events? Or should businesses add clauses for these sort of situations to protect themselves?
Well, if you ask me what I would prefer, I would always prefer the private regulations, as I told you, to regulate COVID clauses, to try to put the will of the parties on the contracts and create the status of this relationship. But well, you know, in Europe, the countries are very protective and try, for example, of the labor matters and even commercial matters as agency, as goal of protection, and it is unavoidable. This regulation is, on my opinion, too much, but this is our continent, no? Is our culture, is our evolution, and for example, during the pandemic, on my opinion, we had too much regulation. Every day there was a regulation, and it was very difficult to try to regulate everything regarding mobility, regarding labor question, regarding how to manage in the companies, with all these new circumstances, etc., etc., etc. And there were a lot of troubles of interpretation and fines, and because nobody or many people did not understood the exact meaning of those regulations and the different cases. So, well, it is.
I would like to.
Yeah.
Maybe I would like to add one thing. There's, I agree with Andres, it's always better to have private regulations for your commercial relationships to prevent those kind of situations. But you need to be aware of some laws in Spain that can be imperative laws that are mandatory, especially when it comes to protective laws, for labor laws, that you, even though you might agree in your agreements, you might put clauses to regulate certain situations, cannot always circumvent those imperative or mandatory laws. But generally speaking, Andres is right, better to have good contracts and prevent those situations for the future.
Great. Thank you guys so much for your input. I think we've lost Miles. He was having a little bit of difficulty as well. So I just want to thank you guys, Consuelo, Nadia, Andres. Thank you so much for spending your time with us. Thank you, Consuelo. We really appreciate the input that you've provided for us. And Baldomero, thank you so much for your welcome. We love having good partners with Spain. I will, for all the participants who are still with us, I will be sending out a recording later on today of this webinar. So if you missed anything, you guys can review that information. Thanks so much for sticking with us even through the technical difficulties, and we will see you later. Have a great evening, you guys.